Namaskar, I'm Dr. Nalini Avinash Wagmare, working as Associate Professor at Tilak Maharashtra Vidyapeeth. This is my brief information. Today's our topic is related to Indian Council Act of 1861. Before that, we have to study the background of introducing that act. So the Charter Act of 1853, the British Parliament passed uh, another Charter Act in 1853, which empowered the Parliament to hand over the governance of India to the Crown anytime, reduced the number of directors to 18, introduced the competitive examination for the civil services, appointed a lieutenant governor in Bengal, nominated 6 additional members to the Executive Council of the Governor General to help him in framing laws, and decided that the salaries of the members of the Board of Council and its officers would be paid by the company. The Act closed the first period of constitutional development in India because of the Crown took up the direct responsibility of administrating India in 1858. As we know that in 1857, first Indian independence movement against the Britishers, revolt of it is also called as another name as 1857 revolt or Sipai Danga, etc. So after that, during the second phase of constitutional development, which began in 1858, after the 1857 revolution, the British government directly taken authorities in their hands instead of the company rule. Indian nationalism gained strength, which forced the British government to give certain concession to Indians by granting them gradually the right of self-government. When we study the socio-economic, political, religious causes of the 1857, the British government, with its efforts, suppressed this 1857 revolt, but nationalism created among the Indians after this or in during 1857 revolution. Then after that revolution or revolt, the Government of India Act 1858 was Act of the Parliament of United Kingdom passed on 2nd August 1858. The main reason is that its provisions called for the liquidation of the British East India Company and the transfer of its function to the British Crown. Instead of East India Company run the administrative things, now introducing this 18 Government of India Act 18 whole authorities in the hands of the British government. Then what points involve the Government of India Act, uh, which include these things are, it is to be noted that the Pitt's India Act 1784 had introduced a double government system, which failed as the board of the control was found to be inefficient to have proper control over the affairs of the East India Company. In the words of Prime Minister Lord Palmerston, the system of double government was complex, inconvenient, and chaotic. In this situation, the company was struggling to come up against the mutiny of 1857, which had given several death blows to the company's regime. Consequently, the British Parliament, for the purpose of better government, passed the Government of India Act 1858 in refined and revised form. Then what points involved in this act? By means of the Government of India Act 1858, the Government of India's sovereignty was transferred from East India Company to the British Crown. Thereafter, our country was to be governed by and in the name of Her Majesty. Means now directly British government ruled the Indian territories. Under the Act of 1858, the Court of Directors and the Board of Control were abolished, and their respective powers were given to one of Her Majesty's Secretary of State. So the appointed to look after the Indians government, the British introducing this act appointed one more person, that is Secretary of State, to look after the Indian affairs. However, the powers of the Crown were to be exercised by the Secretary of State for India, who was assisted by 15 members council to be called the Council of India. The Secretary of State was under legal obligation to prepare an annual account of revenues of India, and he was also required to submit the statement report in British Parliament relating to material progress of the India. Everything he has to send report to them. Then under the Government of India Act 1858, the Secretary of State in Council was considered a body of corporate capable of things being served in India and in England. In the circumstances, a royal proclamation was issued by the Queen of England, that is Elizabeth, by which the company's government was transferred to the British Crown. This proclamation had a great constitutional importance from the historical point of view, as it was end of the company's rule in India, which was established in 1600 and ended in 1858. Later on, the beginning of the another era of direct rule of the British Crown in Indian affairs in India. That is the turning point of this act. Then let's see what were the things related to Indian Council Act. This historical act made the provision of the representative institution in which Indians were given the work of legislation. This act provided foundation of government which pattern constitute till the present day. What were the legislative powers in this act? Let's see, the Governor General in Council constitute the provincial executive. The government of the presidencies had power to make rules for the conduct of the business in the councils. Every governor was empowered to fix times and place of legislative councils meeting. It is to be noted that the Charter Act 1833 had taken away the power of making rules and regulations for their territories from the governor in council to make laws for the persons and courts in British India. But the Indian Council Act 1861 once again restored the governor in council of Mumbai and Madras the powers of making laws of their respective territories. The local legislature had no power to interfere with the executive power of the government. Even the legislation passed by the local legislature could not become law unless it received the assent of the local governor and governor in council, governor general in council. Also, local council could not make laws pertaining to the public debt of India, currency, and coinage. The Penal Code of India, military and naval forces without the prior sanction of the Governor General. Here he has to take the permission of him. Even the legislation passed by the local legislature could not become law unless it received the assent of the local governor and governor generals. Again, it's repeated. Then by proclamation, the Governor General in Council was empowered to constitute legislative council for Bengal and for Northwest provinces and the Punjab. For the validity of such proclamation, the previous assent of the crown was necessary. In 1862, Legislative Council for Bengal was established. However, 1886 and 1897, the legislature for Northwest provinces and for Punjab were established respectively. The legislative councils were composed of the Lieutenant Governor in Council and contained nominated councillors. Notably, the Lieutenant Governor in Council was given power by the Indian Council Act 1861 to make laws for the peace and good government of respective territory. So here, on the other hand, the Council of Governor General was expanded by addition of one more law member who was to be a law expert. In this act also involved that, along with the Indian Council Act 1861 provided 5 ordinary members. Out of these members, at least 3 members must belong to the civil services, and 4th member was to be a barrister or an advocate of 5 years standing at bar. He must be a member of bar. The Secretary of State in Council was given power to appoint the Commander-in-Chief as an extraordinary member of Governor General in Council. Under the Act 1861, the Governor General had been vested with power to make rules for the conduct of business in Council. It is relevant to be stated that in the exercise of the said power, Lord Canning brought the portfolio system in India. Then the Legislative Council of the Governor General. The Indian Council Act 1861 recognized the Legislative Council of the Governor General. This legislative council was composed of ordinary, extraordinary, and additional members. However, not less than six and not more than 12 members could be nominated by the Governor General. So here the members' strength mentioned. In these circumstances, some Indians were also assigned the work of the legislation. No law was permitted to be enforced without the assent of the Governor General. The Governor General had liberty to grant assent or withhold his assent or reserve it for the assent of the Crown. In case of emergency, the Governor General was empowered to make and promulgate ordinances for peace and good governance of territories in India. Then what were the good or merit of this act? The act restored to the Governor General in Council of Mumbai and Madras the power of making laws for their respective territories and authorized the Governor in Council to establish a legislative council for Bengal and also for the Northwest provinces and the Punjab. On account of it, it was possible to make laws according to the local needs and local condition. That is the one important in Bengal, Madras, Calcutta, Mumbai. According to local conditions, they have to make laws and solve the problems. It was a step in the direction of the complete internal autonomy to the provinces. The act may be praised for starting the process of decentralization, means central, state, and district level authorities distributed through this act. It provided for legislative devolution. Most of the non-official members chosen for the legislative councils were Indians, and thus the Indians were associated with the legislative function. So before this, there is no authorities given to Indians to participate and discuss the in legislature. So this act provided that function. This lessens the feeling of distrust prevailing among the Indians. Then let's see why although this act was failure one. The act made a beginning of the legislature in India both at the center and the provinces. Thus, it was a useful measure, but its utility ended there. The act failed to serve the purpose for which it was created. Its primary purpose was to introduce measures for knowing the wishes of the Indians. But on paper it is there, but really not considered Indian wishes in this act. The provision of nominating non-official members in legislature was made for the same purpose. But the provision remained the failure because mostly princes or big landlords who in no way represented the Indian public opinion were nominated as members. The councils, in fact, were there simply to stamp the wishes of the executive councils. Thus, in a way, the act was a reactionary step in the comparison with the Act of 1853. Besides, the Legislative Council, in fact, had no power either concerning legislation or controlling the executives. The power to frame ordinances given to the Governor General was an additional power to him. Therefore, the Act failed to serve any useful purposes. The only thing in its favor was that by creating Legislative Council, it laid the foundation of that system of administration which lasted till the end of the British rule. Decentralization powers and appointing immediate in some for getting legislation knowledge. So these are the books you have to refer for more detail about this act. So here in this act, we have studied the causes of introducing this act, its merits, its provisions or characters, merits, demerits, and references. Thank you.